Hey everybody, access to regulated cannabis and cannabis-derived products has increased exponentially over the last 10 years. But cannabis is still federally illegal under the Controlled Substances Act. And that's why brand strategy for cannabis businesses is a unique challenge. And today I'm going to tell you 3 things you should keep in mind while applying for a trademark registration as a cannabis business. Hey y'all, my name is Solomon Lothra, an intellectual property attorney and a business owner just like you. The cannabis business is booming. Currently, 37 states, 3 territories, and Washington, D.C. regulate cannabis for at least medical use. Out of those, 18 states, 2 territories, and Washington, D.C. currently provide cannabis for adult use. Recently, states like New York and New Jersey issued new licenses for cannabis businesses. And with an already clogged market, it is imperative that you establish a brand within the cannabis industry. That starts with protecting your business's assets, like its name, logo, domain name, and all other proprietary information. Cannabis is a heavily regulated industry, far more regulated than alcohol and tobacco. And that's why you need an intellectual property attorney who understands all these nuances. United States Patent and Trademark Office and the courts allow for all marks registered that are lawfully used in commerce. Now, what does lawfully used in commerce really mean? Well, it's changed, it's evolved because the federal enforcement against cannabis has lessened and decreased exponentially over the last decade as well. And with an increased number of states providing legal use of cannabis, the patchwork of state and federal regulation has provided for unique business opportunities for cannabis-related businesses. As always, if you have any questions, please feel free to leave those in the comments. Me and my staff will get back to you as soon as possible. Now, 3 things to keep in mind when applying for trademark registration as a cannabis business. Number 1, your description of goods and services will make or break your application. The more the description of your goods and services aligns itself to the clear sale of cannabis or cannabis-derived products, the less likely it is that the USPTO will allow your application to move forward. Number 2, ancillary goods and services are your friend. Now, if you are offering goods and or services that clearly violate the Controlled Substances Act, it is always a good idea to also offer goods and or services that fall outside the restrictions of the Controlled Substances Act. For example, a dispensary can also run an informational blog on cannabis and can register a trademark under written cannabis materials. And lastly, be bold. The cannabis regulation landscape is evolving. A trademark lifecycle application with the right type of application can last up to 3 years or even more. It is an inexpensive way to position yourself when cannabis might not be regulated under the Controlled Substances Act anymore. It's a bet, but it's an inexpensive bet. Now you might ask, what are alternatives to trademark registration on the federal level? Well, number 1, state registration. Yes, your state does have a trademark office. States that currently regulate the sale of cannabis and cannabis-derived products will gladly accept your trademark applications, and it'll help you be protected at least in one jurisdiction. Another alternative is establish your common law rights. Use your mark in association with the goods and or services that you're providing. And the more jurisdictions you use that mark in, the more likely it is you will be protected in that jurisdiction. And another alternative, copyright registration. Now, copyright registration might not protect your brand's name, might not protect the slogan or even a phrase, but if your logo is an original work of authorship, it will protect that as an original artwork. And the benefits of copyright registration, well, I've outlined those in another video. If you're currently in or planning to enter the cannabis industry and needs the assistance of an intellectual property attorney who understands the nuances of federal and state restrictions around cannabis, feel free to register for a discovery call in the comments below. And as always, thanks for watching.